So we're all ready to hear Akron Firefighters versus City of Akron. Is everyone ready to proceed?
Yes, Your Honor.
All right, well then why don't we begin? Each side would have 15 minutes and the appellant may reserve up to 5.
Thank you, Your Honor. May it please the court, Stephen Funk, on behalf of the City of Akron, I'd like to reserve 3 minutes of my time for rebuttal.
That's absolutely fine, thank you.
Thank you. This appeal involves a constitutional and statutory challenge to a 20% residency scoring preference in the City of Akron Charter. We request that the court reverse the trial court's judgment on both claims as a matter of law because the trial court applied the wrong legal standards and validated the residency scoring preference in its entirety based upon how it applied to only one fire lieutenant promotion. And third, it wrongfully ignored the city's affidavits and relied entirely upon documentary evidence that was not timely submitted or supported by an affidavit as required by Rule 56C. We therefore request that the court reverse the trial court's grant of summary judgment in the plaintiff's favor and remand with instructions to grant summary judgment in the defendant's favor as a matter of law. Now, with respect to the constitutional issue, there is no dispute that the constitutional standard was set forth by the Ohio Supreme Court in King, and that the burden lies with the plaintiffs to establish beyond a reasonable doubt that the residency scoring preference is unconstitutional in all circumstances. Now, in King, the court upheld a 20% scoring preference for veterans who are also residents of the state of Ohio. In so doing, it determined that the question of whether veteran status merited a scoring preference was essentially a policy judgment for the legislature to make, not the courts, and that the court should not invalidate that scoring preference unless it was so arbitrary and so unreasonable in all circumstances to violate the Ohio Constitution. Now here, the trial court followed that highly deferential standard in upholding the veteran's preference. But for some reason, it did not follow that standard and did not show any deference to the residency scoring preference. And there's really no reason why there should be subject to two different standards. And this point can, I think, best be illustrated by looking at some of the arguments that were rejected in King. Now in King, they also argued that the statute was unreasonable because it permitted military veterans to win civil service positions even if they scored lower on the written examination. What the Supreme Court held in that case was that the Constitution did not mandate that the written examination be controlling, and that the definition of merited fitness was broad enough to include and take into account other factors, more subjective factors, that were beyond the scores of the written examination. And then second, in King, they argued that the statute was arbitrary because it applied to all civil service positions regardless of whether the military training was a relevant factor or not. And also because it applied equally to all veterans, even if it only was they served as a veteran for one day. And they thought that that was arbitrary. In both of those cases, the Supreme Court rejected those arguments because they found that the question was not whether the scoring preference was arbitrary in some circumstances, but whether the policy judgment of the legislature was arbitrary and unreasonable in that it had so little value in any circumstance that it was unconstitutional.
Well, if I could just ask one quick question. It's been a couple
Sure.
of years since I read that, but I thought the veteran had to serve a minimum, you said 1 day. Is that for sure?
In King, that was the standard, was any military veteran who had actually served in certain wars. That was the veteran's preference in King. So one of the arguments they raised in King was, well, you get the same preference even if you're a military veteran for only 1 day. That seems fairly arbitrary. The court said it's not whether it's arbitrary in a particular circumstance, but whether it's so little value in any circumstance that it violates the Constitution. Our veteran's preference is not the subject of this appeal. That preference did have different qualifications for getting that veteran's preference, but the same deference, I think, was owed. The trial court did that in this case for the veterans, but didn't do it for the residency.
Let me ask you a question too.
Yeah.
I understand your argument, but the court did say in its entry after discussing the veteran's preference in King, then went on to say when it was discussing the residency requirements, with respect to residency, the same constitutional considerations apply.
Right, Your Honor, it did say that. He did say that. In fact, that's our point. The same constitutional considerations apply. After saying that, he then went on and said, but I don't think the same, when he was discussing the residency, I don't think the same merit considerations apply to residency that I think apply to veterans. What he did by doing that was he substituted his own policy judgment about the relevancy of residency to civil service than what the voters had decided. Here, the voters made a reasonable policy choice that residency was quote-unquote deserving of a scoring preference. And the courts that have looked at this in the past, and most of the time it was dealing with the residency requirement, this is only a residency scoring preference, but when they looked at this question from a constitutional perspective, numerous federal and state courts have held that there are a number of legitimate public policy reasons for considering residency, including the knowledge of the city, the proximity to the city, and the fact that residents are more vested and committed to the city. And the plaintiffs don't really dispute that in their briefs. What they're arguing is that the question of knowledge of the city, for example, is something that could be tested by a written examination. But the Supreme Court, that argument though makes our point. The Supreme Court in King specifically rejected that argument. They said that written examination was not controlling. Here, the written examination sets the score. You have to pass it to be eligible. But then after that, there are a lot of other factors that are weighed into the ultimate decision, including the rule of three, which is essentially once you get the eligibility list, you still can choose of the top of the three for that position. You don't necessarily have to take the top candidate. So it's clear that the trial court didn't appreciate that fact because ultimately what he focused on was the fact that it was quote-unquote outcome determinative in the case of the fire lieutenants. And again, that's legal error because the Supreme Court, that argument was raised in King and it was rejected. The question is not whether residency is quote-unquote outcome determinative. The question is whether the policy judgment, whether 20% scoring preference is a reasonable decision, policy decision, is so arbitrary and unreasonable that it's unconstitutional in all circumstances. So that same standard, let me just shift real quick to the statutory claim, that same focus on whether it was outcome determinative, that standard is inapplicable to the statutory claim too. Under the Supreme Court and Ninth District precedent that we cited in our briefs, a statutory conflict can arise only upon examination of the plain language of the statute and the charter. That's what this court held in Carroll and the Supreme Court cases cited in that opinion. And on its face, this statute only prohibits municipalities from making residency a condition of employment. It does not prohibit scoring preferences. If the General Assembly had wanted to prohibit scoring preferences, it could have adopted a statute that expressly prohibited scoring preferences. It didn't do that. Rather, the General Assembly, in fact, the Ohio Revised Code has in it its own scoring preference for veterans who are also residents of the state of Ohio. So if you look at the plain language of the charter also does not make residency a condition of employment. In fact, the trial court in its opinion found that the charter did not make residency a condition for hiring, did not make residency a condition for continued employment. What it found was essentially made a factual determination that in the case of the fire lieutenants, it operated to make, it was outcome determinative with respect to the promotion of the fire lieutenants. And we submit that that was error for three reasons. First, it ignored that standard, that you look at a statutory conflict based upon the plain language of the statute of the charter. But second, it also violated Rule 56 because it failed to construe the facts of the Stacy Doty affidavit, which we submitted on behalf of the city, in the light most favorable to the plaintiff. They granted summary judgment to the union here and did not construe those facts in the light most favorable to the plaintiff. Instead, what the trial court did was it relied upon documentary evidence that was later submitted by the city under order of the court, but was not timely submitted as part of the summary judgment briefing, and more importantly, was not supported by an affidavit, and therefore was not competent evidence under Rule 56C. But more than that, the trial court then proceeded to weigh that evidence and to make a factual determination that the residency scoring preference operated as conditioned employment for that one promotional examination.
Are you referring to the matters that were filed under seal?
That's correct, Your Honor. No, we objected to filing that because we believed that all the evidence should have been submitted prior to the close of the summary judgment briefing. And we also objected to that because we felt that evidence should not have been considered as part of the summary judgment motion. But ultimately, in accordance with the court's order, that was filed under seal. But it was not filed, it was not supported by an affidavit. and it was therefore not competent evidence under Rule 56C. And that's one of the points that we repeatedly made in our objections to the city, to the trial court. And here's the reason why that matters, is because the affidavits that we submitted from Stacey Doty were designed to show that over the prior 4 years, the city had hired and promoted a very large number of non-residents. And the plaintiff did not submit any evidence to rebut the facts in that Doty affidavit. But what the trial court then did was it didn't construe those facts in the light most favorable to the city, basically disregarded that affidavit. It discussed it, but it disregarded it, and then went on to rely upon other documentary evidence.
Which reminds me of another question that I wanted to ask you. I know you're asking for the court to reverse, but your arguments tend to be saying that the trial court, again, didn't construe it in the light most favorable to the non-moving party, didn't use the right standards and so forth. Those are really more arguments to reverse and remand for almost like a reconsideration or a redo.
Well, I mean, I think it's ultimately up to the court to make the decision about the appropriate remedy. We do think that reversal is appropriate. Whether a remand is necessary, I think the court can take into account the evidence that is competently submitted, so not taking into account the non-competent evidence, look at the evidence, and then decide whether the plaintiffs satisfied its burden under the applicable legal standard. So in this case, dealing with the constitutional standard, we've already discussed that. With respect to the statutory standard, it's a question of whether there's a conflict based upon the plain language of the statute and the charter. So ultimately, the evidence isn't going to be dispositive of that question. There is no conflict. If the General Assembly wanted to prohibit residency scoring preferences, it would be certainly able to adopt a statute to do that. It didn't do that. It's only prohibiting it as a condition of employment. Trial court specifically found that it was not a condition for continued employment. It invalidated it in its entirety based only upon evidence that was not competent and related only to one promotional examination. So on that basis alone, the court could not have granted summary judgment in the plaintiff's favor, but should have granted summary judgment in the city's favor.
And you're just entering your rebuttal time. Would you like to say that?
I would like to say that. Thank you very much.
Thank you.
Good morning. May it please the court, my name is Ryan Limmerbrock. I represent the Akron Firefighters Association, as well as firefighters Matt Claflin, Randall Reedy, and Doug Price. Article 15, Section 10 of the Ohio Constitution requires appointments and promotions in civil service be made according to merit and fitness to be ascertained where practicable by a competitive examination process. Akron's residency scoring preference for civil service positions and the 20% scoring advantage it gives to residents violates the Constitution in several respects. First, where an Akron firefighter lives has no relation to that firefighter's merit and fitness for a promotion. Making where a firefighter lives as a controlling factor as to whether or not that firefighter should be promoted violates the very basic tenet of the Constitution requirement that civil service positions be awarded based upon merit and fitness. That same thing applies to the residency advantage in that it is outcome determinative. There's no dispute that these competitive examinations are highly competitive with scores that are very differentiated by very small amounts. When you add a 20% scoring advantage, that is undoubtedly going to put those individuals who receive that advantage ahead of those who do not.
But obviously, the same thing could be said with the veterans. 20% scoring, as you say, scoring advantage. And I know that issue is not before us, but an argument could be made that the trial court merely said, I have to follow King on the veterans, and I'm going to rely on the 8th District case to decide the issue of the residency requirement, without really weighing, not weighing, but giving preference to, I'm using the wrong words, I apologize, let me start over, without really viewing everything in the light most favorable to non-moving party and following the standards of summary judgment.
I understood the trial court to have held that 20% for veterans and residency were both outcome determinative based upon their review of the promotional rankings that the trial court received. And I agree with the idea that the trial court ultimately said in regard to King, this may be outcome determinative in both respects, but here in King, the Ohio Supreme Court clearly ruled that this was permissible under the Constitution. And that's really where that analysis ended. But I see a distinguishing between really the veterans as far as the analysis and the residency, because in King, the court evaluated whether or not that veteran's preference had some type of relationship to determining merit and fitness. They looked at other factors that could be considered, like physical fitness, educational background, prior work experience. And they held that like prior work experience, prior military experience could possibly go to determining one's merit and fitness. The trial court acknowledged that, but said that same constitutional review as to whether or not there's a relationship between that preference and determining merit and fitness doesn't apply to residency because there's no correlation.
But I think the question becomes whether in making that determination, the trial court was reviewing the evidence in a light most favorable to the non-moving party, because there are inferences that can be drawn, from the argument that even residency and, the fact that you live in a community could make you more fit or go to the merits of your knowledge of the community.
Well, actually that argument, at the outset of the proceedings, Akron represented to the trial court that it was purely a legal issue that was before the trial court. The Akron Firefighters actually tried to put on evidence at a preliminary injunction hearing, and the argument of Akron was really, you shouldn't hear this. We should only be looking at the constitutional issue and the statutory issue, and evidentiary issues don't play a part in your decision making. And the trial court initially agreed with that. Now, as we continued on in the proceedings, it became clear to us that Akron was actually going to argue that there wasn't enough evidence to support the conclusion that a 20% advantage somehow would adversely impact non-residents. And we repeatedly,
I guess what makes me a little concerned is whenever you say things, and I'm not saying it's just you, it's maybe the other side too, but when you say enough evidence, this wasn't a trial, right?
no.
See, those are the kind of things that I'm getting at, and I think Judge Moore is getting at in regard to the evaluation of what actually happened here. And in looking at it, in what lens do you look at this? I mean, how do you zoom in or zoom out? Are you looking at it as like the weight of the evidence? Are you looking at it sufficiency? Are you looking at who met their threshold burden and who, how did the court look at the evidence that was presented in regard to a summary judgment standard?
First,
I'm sorry.
To
I asked
separate-
a lot of questions there. I apologize.
okay, there's two aspects of our constitutional claim. One is not, I don't think, evidentiary in any respect, and that is the question of whether residency relates to merit and fitness for duty. The second constitutional question of whether it is outcome determinative is arguably supported by some, it would have to be supported by some sort of evidence. And really our argument, because at that time of our action, the scores from the lieutenant's test were not published. They weren't out there. Our argument was, if the city is going to argue that we don't have enough evidence to prove that it's outcome determinative, we would like to reserve our briefing until till that evidence is produced. We can examine, introduce to you, and we can have a discussion as to whether or not our evidentiary burden has been satisfied. And the court indicated we're going to proceed with briefing, and if at a later date it is an issue as to whether or not there is the evidentiary standard hasn't been satisfied as far as showing the impact, I am going to order production of the results at that time. And after the summary judgment motions, that's actually what happened. the court issued several orders for them to produce the promotional eligibility rankings to show what we had argued was evident, that when you grant somebody a 20% scoring advantage, it's going to shoot them to the top of the rankings over the non-residents.
And this is still within the context of competing motions for summary judgment, correct?
Yes.
So to your opposing counsel's point, how is that information properly before the court under Evidence Rule 56?
We made a motion under 56F for the decision of the trial court to be continued until that discovery could take place as far as those promotional rankings, in light of the city refusing to produce these things, because we don't have access to the scores. The firefighters don't. The court granted that motion.
But that was after briefing was all done.
Yes. Yes.
Which the rule says that you ask for that in order to complete your briefing.
Well, I'm aware of case law that we actually cited to the trial court that said after briefing additional evidence, that 56F motion could be filed.
After the opposing party, I mean, after you have filed a brief?
Yes, yes.
Now, I mean, there are other arguments, obviously, that can be made with that, but I'm just wondering in regard to the 56F, so then the court allowed you to proceed?
The court indicated that it was granting our motion.
Okay.
It ordered the city to produce the records. The city actually initially indicated that it would not. The trial court indicated that it was going to hold Akron in contempt. And there's actually a transcript of the proceeding sort of before the trial court where all these issues are laid out in the discussion. But the point of the trial court to Akron was, you initially said this was a purely illegal dispute. You have raised a factual evidentiary issue in your defense of the plaintiff's claims, of the firefighters' claims. But you alone have the evidence that you are saying hasn't been produced to rebut the plaintiff's claims. As a result of that, the trial court said, if you're going to maintain this defense, then I need to have this evidence. And our position is that it was within the trial court's discretion, it was not an abuse of discretion for them to order production of those promotion eligibility rankings in light of the defense that Akron had continued to maintain, which is that harm can't be shown.
At any point before the direct order, after not following the court's direct order to submit the findings, was discovery still ongoing?
No.
It was over at that point?
We had never really done discovery because the argument was that this is legally based, and we had actually asked for the summary judgment motions to be continued so that we could discover this. And we were told, no, we want you to proceed with, the court said, no, proceed with the motions for summary judgment, and if the court felt the need for that information to be produced later, that's what they would do. And that's what we operated under. We were adhering to what the trial court was telling us, that if that's needed, we'll order it later. The city's interpretation of King v. Emmons is incorrect.
Would you repeat that? I'm sorry, I didn't quite hear you.
The city's urged interpretation of King v. Emmons is incorrect. When they say that the King court held that a scoring preference should be reviewed by courts only by considering whether the policy judgment underlying the preference is constitutional, is incorrect. That is not at all what the King court held. The King court looked at, as I said, factors that could be connected to determining merit and fitness. The only discussion of deferring to the judgment of the legislature was actually in response to the plaintiff's claims that the amount of the scoring preference was arbitrary. The court said that if the military experience can be considered as it correlates to merit and fitness, then it is not our place to second guess the decision-making of the legislature as to the amount of the preference that they award. There was no indication that it was just deferring to the policy judgment of the legislature in enacting that. The city, in arguing that interpretation of King, really largely ignores the express requirements of Article 15, Section 10. So when it says the constitutional civil service requirement is guided by King, it's guided by what Article 15, Section 10 says. If you look at IAFF v. Dayton, similar to King, in looking at directly whether there is a connection between the scoring preference and fitness and merit and fitness, the Ohio Supreme Court in Dayton likewise considered whether an apprenticeship program warranted a scoring preference and whether that had some correlation to determining the candidate's merit and fitness. They held that it did. They recognized that that scoring preference was properly allied to qualifications to determining merit and fitness. Adhering to King, adhering to Dayton, the trial court examined residency under the same analysis. Is there some correlation between residency and merit and fitness? They found that there was none. Now the city is saying, well, there is some connection if we look at municipal residency requirements and the cases that have upheld those. Those factors are not at all related to determining the merit and fitness of civil service candidates. Those factors cited in those cases, first of all, obviously residency requirements are now illegal in Ohio, and the case law that they cited to involves equal protection claims and an alleged right to interstate travel, which the Akron Firefighters are alleging here. There's no discussion in those cases of civil service or scoring preferences or whether there's some connection to merit and fitness. What those cases cite as a potential basis for the residency requirements is that after the employee is hired, there are things that could materialize that benefit the employer or the community, like improved race relations, improved ethnic balance, a higher stake in the community, faster emergency response times. These are all things that these cases said this could happen if the employee stays in the city after they attain the position. We're talking about how the civil service requirement of the Constitution requires an employer to evaluate the qualifications of the employee before they go into the position. Those factors don't have to do with how the merit and fitness of the individual for the position that they're being considered for.
And Council, your time is up.
Thank you.
Thank you.
Very briefly, with respect to King, I think the best way to understand this is it all depends on the definition of merit. The Supreme Court in merit, he made another argument saying it's not allied to merit and fitness. Well, the definition of merit is what is the policy judgment. The court said that merit, Supreme Court said, means deserving well. The legislature, in our opinion, was amply within its powers, providing that veteran status was deserving of a scoring preference. And then they went on to say, it is not for us to decide what represents the wise or best public policy. It's for the legislature to say that. So the question isn't, is it allied to merit and fitness? The question is relevancy, is it reasonable for the voters of Akron to make the policy choice that residency is deserving of a scoring preference in the same manner that was done in King? So with respect to the arguments about what was the procedures below, we did argue at the beginning of this case that that question, whether or not residency had merit, was a legal determination that the court could make without considering any evidence, because it was a policy judgment that the court should defer to the voters' judgment on. And secondly, we argued that evidence wasn't relevant to the statutory issue, because that turned solely on examining the plain language of the statute and the charter. Now, the trial court ultimately proceeded with the preliminary injunction hearing, received evidence, and then granted a preliminary injunction based upon that evidence. So he did not agree with our argument on that. He accepted it. In that event, we then set this up for summary judgment. The plaintiffs moved for summary judgment. They supported their summary judgment with transcripts as well as affidavits. We then responded to the summary judgment motion with our own affidavits, including the affidavit of Stacey Doty. Plaintiffs did not, at that time, move for Rule 56F, seeking more discovery. They did not submit any affidavits to respond to the Doty affidavit. They filed their own reply brief that essentially argued the case based upon the evidence that had already been submitted. We then filed a final reply brief that said, look, even if you consider the evidence, they did not meet their burden. And they ultimately backed away from the legal arguments and turned more on an outcome determinative argument that we said was not relevant under King. And Judge Carr, you're correct that if that was the case, then the court would have invalidated the veteran status preference in King. It didn't do that. That was also a 20% preference. And it was also not relevant under the statute. But in the alternative, we did argue that if you look at the facts and whether it was outcome determinative, looking at the Doty affidavit alone shows that it is an outcome determinative in all circumstances. And that's where we got to the part where the court, sua sponte, after all the briefing was done, sua sponte ordered the city to provide additional documentary evidence. We objected to that. We said that that was not competent evidence under Rule 56. We argued that it should have been timely submitted during the summary judgment briefing, and we did object to that. Ultimately, the court ordered us to do it anyway, which we complied with. It was filed under seal, but we still did that without waiving our objections. We continue to argue that that was not competent evidence, it was not timely submitted. And the Rule 56F affidavit, you're right, Your Honor, they were not seeking more discovery. They didn't get more discovery, and they weren't seeking more discovery. They were looking to, after the fact, justify the trial court's sua sponte orders. And ultimately, it doesn't matter because the evidence that the trial court relied on was not competent evidence. But then, one last point.
You're out of time.
I'm out of time, okay.
Yes.
We just asked that the court reverse the judgment and at a minimum determine that the trial court did not err by invalidating the scoring preference in its entirety based solely on that documentary evidence as to one promotion. Thank you.
Thank you. Thank you to both sides for presenting your arguments to the court. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as we will release it on our court website, Supreme Court website. Thank you very much.
Thank you, Your Honor.
Thank you.